The United States has locked up more people for drug offenses than any other nation on earth. At its peak, America was imprisoning nearly 500,000 people for non-violent drug crimes in a single year. And the laws that made that possible did not emerge from science, medicine, or public health research. They emerged from fear, racism, and political ambition. That is the story nobody tells you when they talk about drug policy in America. In the next 10 minutes, you are going to discover how a country that once had virtually no federal drug laws at all transformed into the world's largest jailer of drug offenders. You will learn which powerful figures deliberately manufactured a crisis to advance their own agendas, how certain laws were written specifically to target minority communities, and the one uncomfortable truth about the war on drugs that a former Nixon aide actually admitted on the record decades later. Once you hear it, you will never look at American drug policy the same way again. To understand where we are, you have to go back to where this all started. In the 19th century, the United States had almost no restrictions on narcotics whatsoever. Cocaine was an ingredient in Coca-Cola. Morphine was sold freely at pharmacies. Heroin was manufactured by Bayer, the same company that makes aspirin, and was marketed as a cough suppressant for children. Opium dens operated openly in major American cities. This was not considered a law enforcement problem. It was considered a medical and commercial matter. The first significant shift came with the Pure Food and Drug Act of 1906, which required manufacturers to list certain ingredients on labels. It was not a prohibition, but it was the first crack in the wall of unrestricted access. The real turning point arrived in 1914 with the Harrison Narcotics Tax Act. On its face, this looked like a tax law. It required anyone who produced, imported, or distributed cocaine and opiates to register with the federal government and pay a small tax. But the way it was enforced turned doctors who prescribed these substances to addicts into criminals. Within a decade, thousands of physicians had been prosecuted. A medical approach to addiction was being criminalized and replaced with a law enforcement approach. Alcohol, of course, followed a similar trajectory. Prohibition began in 1920 with the 18th Amendment and ended in 1933 with its repeal. What most people do not connect is that Prohibition's failure did not slow down the appetite for drug criminalization. If anything, it redirected it. The Federal Bureau of Narcotics, created in 1930 under Harry Anslinger, became the institutional home of aggressive anti-drug enforcement. And Anslinger's most significant target was marijuana. But here is what nobody talks about. Anslinger's campaign against marijuana was not built on medical evidence. It was built on deliberate racial fear-mongering. Anslinger publicly and repeatedly linked marijuana use to Black and Latino communities, using openly racist language in press releases and congressional testimony. His arguments were not challenged by science. They were amplified by a compliant press. The Marijuana Tax Act of 1937 effectively criminalized cannabis nationwide. There was almost no serious scientific opposition presented at the hearings because the American Medical Association was given only 2 days' notice before the bill was voted on. By the 1950s, Congress was layering mandatory minimum sentences onto existing drug laws. The Narcotic Control Act of 1956 imposed 2 to 10-year mandatory minimums for first-time marijuana possession. A second offense could bring 5 to 20 years, with no possibility of parole. These were not sentences designed around rehabilitation. They were designed around punishment and deterrence. And they were falling disproportionately on communities of color across the country. Then came the 1960s, and everything changed again. Marijuana and psychedelics spread rapidly through white middle-class youth culture, anti-war protests, and college campuses. Suddenly, the drugs that had been linked exclusively to marginalized communities were now associated with political dissent. And that is when drug policy became explicitly weaponized for political purposes. Richard Nixon declared the war on drugs in 1971. He called drug abuse public enemy number 1 and pushed for expanded federal enforcement powers, mandatory sentencing, and no-knock warrants. The Controlled Substances Act of 1970 created the 5-schedule classification system that still exists today. Schedule 1, the most restrictive category, was reserved for substances deemed to have no accepted medical use and a high potential for abuse. Marijuana was placed in Schedule 1, alongside heroin, while cocaine was placed in Schedule 2, meaning it was recognized as having some medical utility. Now, here is the part that should genuinely disturb you. In 1994, John Ehrlichman, Nixon's former domestic policy chief, gave an interview that was published in Harper's Magazine in 2016. He stated, and these are his words, that the Nixon administration had two enemies, the anti-war left and black people. He said that by associating the anti-war movement with marijuana and black people with heroin, and then criminalizing both heavily, they could disrupt those communities and arrest their leaders. He said they knew they were lying about the drugs. That is not a conspiracy theory. That is an admission from a senior White House official. The Reagan administration escalated the war on drugs dramatically in the 1980s. The Anti-Drug Abuse Act of 1986 introduced one of the most notorious sentencing disparities in American legal history. It established that possession of 5 grams of crack cocaine triggered the same mandatory minimum sentence as possession of 500 grams of powder cocaine. That is a 100-to-1 disparity. Since crack cocaine was predominantly used in black communities and powder cocaine was predominantly used in white communities, the practical effect was racially discriminatory sentencing on a massive scale. The U.S. Sentencing Commission acknowledged this disparity repeatedly, yet Congress refused to eliminate it until the Fair Sentencing Act of 2010, which reduced the ratio to 18-to-1. Still not equal, but significantly reduced. By the early 1990s, incarceration rates for drug offenses had exploded. Between 1980 and 1997, the number of people incarcerated for nonviolent drug offenses in the United States increased by a factor of more than 11. State and local prisons were overwhelmed. The 1994 crime bill, signed by President Clinton, added fuel to the fire by incentivizing states to build more prisons and require prisoners to serve at least 85% of their sentences. The mass incarceration era was fully underway. But here is what nobody talks about when they analyze these statistics. The enforcement of these laws was never uniform. Study after study, including a landmark report from the American Civil Liberties Union in 2013, found that black Americans were nearly 4 times more likely to be arrested for marijuana possession than white Americans, despite comparable usage rates across racial groups. The law said one thing on paper. The enforcement told a completely different story. The first serious cracks in this framework came through state-level ballot initiatives. California passed Proposition 215 in 1996, legalizing medical marijuana and directly defying federal Schedule I classification. More states followed. By 2012, Colorado and Washington became the first states to legalize recreational marijuana for adults, creating a direct conflict with federal law that the Obama administration chose not to aggressively prosecute. Today, over 20 states have legalized recreational marijuana, and the federal government still classifies it as a Schedule I substance. This contradiction sits at the center of every conversation about modern drug policy. The First Step Act, signed in 2018 under President Trump, represented a bipartisan effort to reduce some mandatory minimum sentences and allow retroactive sentencing reductions for certain drug offenses. It was the most significant federal criminal justice reform in decades, though critics noted it did not go nearly far enough. The Biden administration moved in 2022 to pardon all prior federal offenses of simple marijuana possession and initiated a review of marijuana's Schedule I classification. In 2024, the DEA proposed moving marijuana to Schedule III, a significant but still incomplete shift. The evolution of drug laws in America is not a story of science informing policy. It is a story of policy being used as a weapon, first against immigrants and racial minorities, then against political dissidents, and then perpetuated through institutional inertia long after its origins became undeniable. The Controlled Substances Act framework built in 1970 still governs the most significant drug policy decisions in this country. Before you go, if you learned something valuable today, hit that like button right now. Subscribe to Legal Brief for a brand new video every single day. We will see you in the next one.